Hey y'all, Daniel Sherman here. Posted a video on preliminary hearing and effective cross-examination. So want to talk a little bit about the video and what a preliminary hearing is. In Kentucky, most cases start off in district court. District court does not have jurisdiction over felony cases. Only the circuit court has jurisdiction over felony cases. So when the case starts off in district court, the person will be arraigned and preliminary hearing will be scheduled. A preliminary hearing is a probable cause hearing. It's a chance for the courts to maybe weed out some cases. Also, it's a chance for some of the charges that really kind of borderline felony, borderline misdemeanors, for it to be worked out potentially between the county attorney's office and the defendant. So that is what a preliminary hearing is. Most people do not have their preliminary hearings. It's more of a formality. The probable cause standard is very low. I wouldn't even call it a probable cause standard. It's more of a maybe cause standard. So a lot of times people do not use them effectively. I probably have preliminary hearings in about 50% of my cases. I know that's a lot more than most people, but I really use them as a tool. And you can use preliminary hearings as a tool for a variety of different reasons. One reason I use a preliminary hearing is to get the police officer on the record it's sworn testimony. So if the case is tried later or there's a pretrial motion, that the police officer cannot, change his story because he'll have been under oath. I've used that in several trials. I've used it in several suppression hearings where the police officer tried to change the story and they just weren't able to, and the jury, looks at that. So that is one effective way to use a preliminary hearing. Another way to use a preliminary hearing effectively is to ask the court for a bond reduction. So the court usually only has in front of it a pretrial service score, what the guy is charged with in his criminal history. Don't know a lot about the facts of the case. And so not all charges, even, not all burglary charges are created equal. Some are, more heinous than others. Some are more mundane. For instance, if you get an individual, boyfriend and girlfriend, got into a fight, girlfriend kicked boyfriend out, boyfriend comes back 2 days later to get his stuff. Okay, maybe he didn't have a right to enter the place, he's not on the lease. That could be burglary second. That's a lot different than somebody who, breaks into your home, starts stealing your stuff. That too is burglary second. So those are not, even though the charges are the same, obviously the facts aren't the same. So I use preliminary hearings a lot to help my case when it comes to bond reductions, to show the judge, hey, look, this isn't as bad as, the charges are. Another way to use a preliminary hearing effectively is if you, especially in kind of high profile cases, you want the community to know, hey, here's the facts of the case. You'll see that a lot. I've had a few murder cases where we've had preliminary hearings where, the news is there and the courtroom's packed and the people are, wondering about the case, and you can have that preliminary hearing to kind of, set the community straight, especially in a small community that I live in Western Kentucky. So that's what preliminary hearings can be used for. I usually only waive unless it doesn't do me any good to have the hearing or it will be detrimental to the hearing. Some of those examples would be if I tell the county attorney, hey, will you, agree to let my guy out, agree to a bond reduction, we'll waive the hearing. that helps a lot, because the main thing, your main job as a defense attorney is get your client out of jail. I also can, you may not want to have the hearing especially if it's a sex offense case. You may not want to taint your jury. And if the guy's sitting over there in a jail cell with a bunch of other inmates that are in the courtroom listening to the case, it might not be in his best interest or her best interest for the his cellmates to hear, oh, this guy is an alleged sex offender. It can maybe not go very well for him in prison. Another reason to do it would also be if you don't want the community to kind of hear the facts of the case, especially if it's one where it could be, sometimes a murder case, a lot of times it's going to be a sex offense case that you're not going to have it. Another reason, you may just not get anything from it, but if there's something that I can get from it, I almost will always have a preliminary hearing. Like I said, I have about 50% of the time I do preliminary hearings, where I would say the average public defender only has about preliminary hearing 10%. I'm not a public defender, I'm a private attorney, but I do use preliminary hearings as a tool. In the next video I'm going to break down the preliminary hearing that I posted and kind of go through why I used it and how it was beneficial.